Hello, and welcome to Assisting Court Patrons, Legal Information versus Legal Advice. I am your presenter, Jill Roberts, the Supervising Senior Program Manager with the Access to Justice Division at the Administrative Office of the Illinois Courts. During this session, we will talk about the challenges of self-represented litigants, also called SRLs, for both the courts and for the SRLs themselves. We'll also cover the safe harbor policy, which talks about what is legal information and what is legal advice. And there are two accompanying documents with this webinar. There is a quiz and a list of 6 scenarios. You may want to complete them now before starting the webinar, or you can pause the program after you've learned more about the safe harbor policy to make more informed responses before we review the answers. Let's start with a question. What percentage of circuit court judges in Illinois do you think said that the presence of SRLs makes their job harder to do? 47%, 62%, 86%, or 98%? The correct answer is 86%. In fact, 86% of judges say that SRLs make their jobs harder, but 98% is the percentage of circuit clerks who say SRLs make their job harder. This is based on statewide data from a survey that was done a few years ago. And it is a pretty common response that SRLs are framed as problematic or making court staff jobs harder. The interesting thing is that the reasons that judges and clerks say they are problematic, shown here on this chart, are things like not understanding court procedure or turning in incomplete forms. And these are things that are also frustrating to the SRLs themselves. They want to have that information. They want to have correct forms. And the great thing is that everyone watching this program, all clerks, all court staff, anyone working for the court can provide that information to SRLs. Even the issue at the very top of people wanting legal advice. After our conversation today, you will learn that most people are asking just for information rather than advice, or you at least could reframe the question and give an answer that provides them with just information. All of us can provide that information that SRLs want and that make judges and clerks and court staff jobs easier. It is a win-win-win. I want to take the time to think about SRLs for a minute and the challenges that they face coming into court. Legal jargon, complicated procedures, confusing forms, opposing counsel, which could leave them feeling intimidated or on an uneven playing field. Crowded courtrooms are nowadays needing to figure out technology to be able to attend court, and high-stakes conflicts with very important issues for the litigants. Let's try and flip the script from SRLs being a challenge to SRLs facing challenges. And if we approach all of our court patrons with an unconditional positive regard, we can be part of the solution for everyone. When thinking about serving court patrons, keep in mind 2 things. The ultimate goal of the court system, and the obstacles that your office faces. All members of court staff should have the goal of instilling public trust in the courts, because without that, the entire system breaks down. Every one of us that a court patron encounters, from sheriffs at the door to clerks to justice corps fellows to law librarians, any court staff, either help or hinder someone access the courts. We are the gatekeepers of justice, and we should strive to ensure that everyone has access to the courts. Of course, there are challenges and obstacles to that. The most frequently stated challenges are encountering aggressive or angry customers with unrealistic expectations, and time constraints and being understaffed. However, there are solutions to those obstacles. Today, we'll talk a little bit about customer service skills that you can use to diffuse situations with angry or frustrated customers. And if we empower court patrons and give them the resources and information that they need, they will be able to help themselves and won't be such a time burden. Now let's think about a time that you've experienced good customer service and also a time when you've experienced bad customer service. I know we've all been there. For bad customer service, the most common characteristics that are stated are representatives being inattentive or rude, not giving explanations for what's going on or why something happened, being condescending or dismissive, or not being knowledgeable about the issue or potential solutions. Whereas characteristics of good customer service are stated as actively listening, giving eye contact, being aware of your body language, don't cross your arms or point at litigants, or turn your back. This also could include good first impressions, so how you start things off set the tone for the entire interaction. Greet everyone with a smile and a friendly greeting, and it could go a long way. Explaining the process. This is something that you'll learn about when we talk about the safe harbor policy. It is definitely allowed. Also, being willing to help. Building a rapport with a court patron can be really helpful. Ask probing questions or clarifying questions. Offer explanations or resolutions. Use power words like absolutely or I'd be glad to. Also, a good characteristic is being knowledgeable. Know what to do and how to do it. Be the expert so that they can turn to you, or if it's something that you're not an expert in, sending them to where they can get the information. And lastly, being calm. You set the tone. Never try and match a court patron's volume or excited tone. If you keep calm and speak slowly, it'll go a long way. Unfortunately, there are going to be those difficult, angry customers that you encounter from time to time. So we want to give you one more trick for dealing with those challenging patrons, especially during this current time when people could be generally upset about the pandemic and the economic situations and state of the world, and even things like wearing a mask in your courthouse. So here is a strategy for diffusing situations called LEAST. The L stands for listen. Don't tell a patron to calm down and just let them vent or get information out. Of course, this is within reason. You can't spend 3 hours listening to someone's story. The E is for empathize. Acknowledge that as a person, you understand what they're going through and let them know that you would be upset too in their situation. A is for apologize. Apologize for the situation that they're in or that they received incorrect information. This is challenging. It's not within our human nature to apologize, especially for things that aren't our fault, but it helps diffuse situations. The S is for solve. You can solve a lot of issues with referrals, alternatives, choices, explanations, and even explanations of what your limitations are. And lastly, thank. Thank them for their understanding, thank them for their patience. This is also counterintuitive, but will be most helpful. So what is legal information? That is what we're here to talk about today. So first, it's general factual information about the law or legal process. It is the same for everyone, so it is universal to both sides, to every person asking about a particular issue. It is also neutral. It doesn't help one side over another, and anyone can give legal information. On the other hand, legal advice is the application of law to particular facts, telling people what to do in their specific situation. It changes as you talk to different people, If you find yourself needing to know a lot of details about what's going on in someone's case, the response you're formulating based on those specifics might be leaning towards advice. And only lawyers can give legal advice, and only when they are working in their capacity as a lawyer and entering into an attorney-client relationship, even if just for brief services. So even those of us who are lawyers but are working or volunteering at the court as a court representative, you cannot give legal advice, only legal information. So easy ways to spot information versus advice. The quickest way to think about this is if you have to make any sort of determination or analysis, it is probably legal advice. If you are just reciting the law, process, procedures, options, it's probably allowable legal information. So for legal information, again, facts about the law or legal process, signals in the questions that the person is asking are who, when, where, and how, and it's objective. You shouldn't need those details about the case. Legal advice is deciding about a course of action that someone should take. The question signals are should or what, but even if a question starts with should or what, you could still answer it with information. And it is subjective, meaning it requires those details of a case. So the guiding authority for what sort of services you can provide and what you cannot provide are in the Illinois Supreme Court policy on assistance to court patrons by circuit clerks, court staff, law librarians, and court volunteers. It was first adopted by the court in 2015 and was amended in November 2018. The shorthand for this policy is the safe harbor policy for a couple of reasons. One is that is a very long name. The other is that this protects you about what services you are allowed to give to court patrons. So here are the things that you can and cannot do regarding information listed in black and white. So the purpose of the safe harbor policy is to provide guidance to circuit clerks, court staff, law librarians, and court volunteers acting in non-lawyer capacities as to what services may and may not be offered. And you want to think in particular about providing that assistance to achieve fair and efficient resolution of their cases. Also important to note that no court patron should be denied services permitted under this policy on the basis of being self-represented litigant. So services to court patrons should not be provided in any sort of discriminatory manner, and that's for any of the listed potential categories of prohibited discrimination. So Section D of the Safe Harbor policy is the one you want to pay particular attention to. These are all the things that you can do. There are 19 main paragraphs with multiple subparagraphs. And these are the permitted services to assist court patrons. And I want to point out before we get into what those services are, that the paragraph states as resources and expertise permit. So we want to take into consideration the fact that you are not going to know every single thing that someone is asking you, and you may not have time or capacity to spend a lot of time with an SRL on their question. So this is all a balancing act. If you know something or could easily find it out to help someone, great. If you don't know or don't have time, at least point them in the right direction. Again, we are trying to provide information to SRLs not only to help those people, but to help ourselves, to help our colleagues, to help judges, to help everyone in the court system so that things run more smoothly. So what are some of these services that we all can provide? One, we can provide legal information about rules, terminology, procedures. And again, if you remember that chart from early on, court procedure and knowing the process is one of the biggest complaints from judges and circuit clerks about SRLs. So the more we can provide information about procedure, the better off we'll all be. You can provide information about and help with e-filing and the e-filing exemption. You can identify forms and instructions and explain the nature of the information required to fill out the forms. You can also record verbatim onto forms in some circumstances. You can inform patrons about legal resources and referrals and encourage them to get advice from a lawyer, and provide services based on the assumption that the information they provided you has been accurate and complete, and provide other services consistent with the intent of the policy. This is nowhere near the complete list. I think I mentioned before there are 19 main paragraphs of what you can provide, but these are just some to highlight. I do want to point out that Section E of the policy talks about unauthorized practice of law. So we often hear that court offices have internal policies about not providing any information to people, or just generally that court staff have a fear of telling court patrons anything because of it being considered unauthorized practice of law. The reason that this document is called the Safe Harbor Policy, in addition to just not wanting to say that full title, is that this paragraph makes clear that the services that are permitted under Section D are not unauthorized practice of law. So this policy protects you and it keeps you safe from any such claim. Moreover, we have confirmed with the Illinois Attorney Registration and Disciplinary Commission, or the ARDC, that they have never prosecuted a clerk or court staff member for unauthorized practice of law. So I want to assuage any fears that people might have that you will be prosecuted for unauthorized practice of law. As long as you stay within the confines of the services in Section D, which even includes that kind of catch-all of anything in alignment with this policy, you are, as a baseball umpire would say, safe. So now we're moving on to what you cannot do. What are the prohibited services under the Safe Harbor policy? According to the policy, you shall not deny SRL access to the court or any services provided to others. This means you cannot have any services in your office or areas of your courthouse that are available to lawyers but not to SRLs. You cannot recommend whether a case should be brought or comment on the merits or give an opinion about what will happen if it is brought. You cannot refer to a specific lawyer or law firm for fee-based representation. And you cannot provide legal analysis, strategy, or advice, or perform legal research other than assistance in self-guided research. Again, this is not the complete list. There, of course, in the policy itself under Section C, you will see the 9 main paragraphs of what you cannot do. So if you remember, for what you can do, there were 19 main paragraphs with subparagraphs. There are only 9 prohibited services. So I point that out just to say how expansive the policy is on the types of services that you can provide that fall within allowable legal information. So in addition to the 3-page policy that we've been talking about, that I hope all of you will read completely, there are also some supplemental materials that we created based on feedback we got about the policy. So the first is a guide called What is Legal Information? A Guide to Using the Illinois Supreme Court Policy. And it is about 15 pages long, and it goes into several sections of the policy in more detail. There's also a desk card, which you can keep at your desk, as the name infers. It's It's an internal document for court staff to have at their desk to quickly reference what you can and cannot do. On the back of it, there's information about common referrals. And so again, it's just a really helpful, useful resource to have on hand, as well as a public-facing flyer that tells court patrons in a very brief summary what you can do and what you cannot do. This has been translated into Spanish, and these resources are available to you on the illinoiscourts.gov website, and we're happy to send you hard copies and laminated copies if that's helpful as well. So now it's going to be time to get into the answers to the quiz and to the scenarios. So if you haven't already done so, this would be the time to pause this presentation and complete the accompanying quiz and scenarios. Question number 1 on the quiz. Can you look up my case number for me? Is that information or advice, and under what part of the safe harbor policy? This would be information. This is allowable under section D12, that you are allowed to provide docket information to court patrons. Question number 2, I need to reschedule my court date. How do I do that? That is also legal information. Under section D1 of the safe harbor policy, you're allowed to provide information about court procedures. Also, under section D7, you can assist court patrons in identifying approved forms. And so you could point out either the motion form or a motion to continue or reschedule, whatever it might be in your local jurisdiction. What should I write so the judge will grant my motion? This on its face is advice. So under section C7, you would not be allowed to provide legal analysis or strategy. Under section C8, you cannot tell a litigant anything that you wouldn't repeat in the presence of another party involved in the case. And C9, you can otherwise engage in the unauthorized practice of law. But that said, under section D7, you can again identify the approved forms and the instructions that go along with those forms, and always D11, encourage self-represented litigants to obtain legal advice from a lawyer. Number 4, can you look over my paperwork to see if I filled it out completely? A lot of people might think this is advice, but it is actually information. Section D9 allows you to review finished forms and documents to determine whether the forms are complete, including checking for signature, notarization, correct county name, and case number. This does not, however, allow you to look it over for accuracy. Accuracy would require you to make a determination, which would cross the line. And again, anytime you're analyzing something or making a determination one way or the other, that's where you cross the line to advice. Number 5, the judge suggested mediation. Is it worth it? And how do I find one? So the question of is it worth it would be advice. So you cannot, under C3, recommend whether a case should be brought or comment on the merits of something. C4, give an opinion about what will happen if it's brought. Or C7, provide analysis or strategy. But for the second question, how do I find one? That is information. Under D10, the policy specifically says that you can inform court patrons of legal resources and referrals, including but not limited to alternative dispute resolution services, which is what mediation is part of. Number 6, the font on these forms is too small for me to read. Can you fill it out for me? This is another one where a lot of people would probably say no, they can't, and it's advice. But actually, It is information in certain circumstances. So under section D8, you are allowed to record verbatim information provided by the self-represented litigant on approved forms if that person is unable to complete the forms due to disability or literacy barriers. Additionally, under section D3, you can inform court patrons of the process for requesting a reasonable accommodation due to a disability as well. So this is just kind of a heads up to be thinking about. Many court patrons do have disabilities, and disabilities can be invisible. If someone says they have a disability or says they have a condition that affects a major life activity, like reading in this case, you don't need to question them anymore or analyze if you think they have a disability. If you want to know more about working with court patrons with disabilities, you can reach out to your court disability coordinator. There should be one in every courthouse. Or you can also reach out to the Attorney General's Disability Rights Bureau, who is the office that oversees the training of court disability coordinators in our state. One other wrinkle to this question is, what if that person had said that they don't speak or read or write in English and ask you to fill it out for that reason? That would be considered advice because you're no longer recording verbatim what someone says. You are having to translate that information on your own, which makes it no longer verbatim under section D8. However, even with that, you could still, under section D2, inform court patrons about the process for requesting a foreign language interpreter. And under D7, assist court patrons with forms and, when appropriate, share information about approved and translated forms and instructions. Those translated forms and instructions can be used for demonstrative purposes, but they cannot be used to be filed with the court. So that's something to remember as well. Number 7, what happens if I plead guilty in my case? This is advice. Under C4, you cannot give an opinion about what will happen. And under C7, you cannot provide analysis, strategy, or advice. But again, under D1, you could provide information about the court process, so you can tell them procedurally what happens when someone pleads guilty in a case. And of course, D11, encourage them to get advice from a lawyer. Number 8, I want to get rid of my public defender. Can you give me the number for a criminal defense attorney? Generally speaking, that is advice. Under section C5, you cannot refer a litigant to a specific lawyer or law firm for fee-based representation, but under D10, you can make referrals to many categories of lawyers, from legal aid to pro bono to limited scope, as well as lawyer directories through state or county bar associations. So there's a lot of different types of referrals that you can make with that one limitation that would be considered advice. Number 9, I can't afford my court fees. What should I do? This is information under section D4. You can inform court patrons of the process for requesting a waiver of court fees due to inability to pay, and provide the required approved form to them. And our last quiz question, number 10. I'm trying to e-file my paperwork. What case type do I pick? This is information. Under section D5 of the Safe Harbor policy, you can provide information about e-filing, including but not limited to selecting a case type. Now let's get into some more in-depth scenarios. Someone comes to your office and is very upset. They just got to the courthouse at 1 p.m. and were told that their hearing was actually at 10 a.m. they had written it down wrong. They already missed the court call and a default judgment was entered against them. They were told by the person in the courtroom that you would be able to help fix it. How would you respond to this court patron? Of course, court staff can't fix things for people or do the work for people, but we can provide information to court patrons so that they have information that they need to take actions that they choose. You can tell the court patron that they have the option to file a motion to vacate the default judgment and have their case heard again. It is just the court process. The information must be presented as neutral and not as advice. You can tell either side about the court process when the case is ended because either side didn't show up. It is part of the court process that if a case is dismissed for want of prosecution when a plaintiff fails to appear, they can file a motion to reinstate the case. It is part of the court process that if a default judgment is entered against a defendant who fails to appear, they can file a motion to vacate that default judgment. Court staff can also provide you with the statewide motion form to complete and file, or any other approved form that your court uses, maybe specifically to reinstatement or vacating a default judgment. Additionally, you want to be sure that you're not crossing the line into advice. You cannot tell someone that they should file something or what that motion should say or what will happen if they do or don't file it. Those would be crossing the line into prohibited services of giving an opinion about what will happen if a case is brought or making a recommendation about whether something should be brought. Moving on to scenario number 2. Pat comes into the courthouse and tells you they want to get remarried soon, so need to file for divorce. They want to know how long their case will take. They have no clue where their spouse lives, but heard they may have been deported. They also don't have a computer in their house. How can you help Pat? Well, there are a lot of different issues in this scenario, but many different ways that you can provide assistance. First and foremost, you can explain the court process. This includes all aspects of the court process, from filing to serving summons to going to court, the entire process. This also could potentially give them an idea of how long a case might take. If your courthouse happens to have an early resolution program for divorces, that might be something to also mention and refer them to. When it comes to the court process for service of summons, you may want to make sure that you provide them with all the options, especially since they specifically mentioned they don't know where their spouse lives. You certainly don't want to jump to giving any sort of advice about having to do service by publication, but you want to let them know the options for service, from starting with the sheriff to a special process server for publication after due diligence. That information, along with general information about divorces, can be found at Illinois Legal Aid Online. Their divorce resources are very robust, and referring to them is allowed under the safe harbor policy. You can also give them the forms, the statewide standardized forms for divorces. We have them for both children and without children. And Illinois Legal Aid Online has automated interviews to guide people through filling out those forms as an extra resource. And when it comes to the mention of not having a computer in the home, this should trigger what information you provide them about how to file their paperwork. Of course, e-filing is mandatory, and you can explain that to the court patron. And potentially, they would want to e-file, and you can help them through all of the steps of e-filing according to Section D5 of the policy. However, you also can explain and provide the exemption form, since not having a computer at home is one of the bases for an exemption. Scenario number 3. Chris's daughter was arrested recently. Chris thinks she has a court hearing today, but isn't sure where or exactly when. Chris asks you, when will my daughter be able to get out of jail? Is there anything I can do to help get her out? How do you answer Chris? This is a situation that you may or may not be familiar with based on whether you serve in a civil court, criminal court, or one that handles both types of cases. But you can always provide docket information to someone if they have specific questions about where or when a case is going to be heard. Section D12 allows you to provide all of that docket information. So that is certainly something that everyone can help with. You also potentially could explain the bail process. It is part of a court process, and you could explain where to pay, how to pay, when that happens, what happens after you've paid, before she gets out, all of that. However, you may not have this information. So I do want to remind you, of course, that all information and services you provide under the Safe Harbor policy are as expertise and resources allow. But if you don't know something, especially if you hear that question quite frequently, this may be an opportunity to reach out to other departments in the courthouse to find out. So if you don't know specifically about the bail process, reach out to court partners like the sheriff's office to get more information so that you don't have to take the time to look it up or tell them every time. You potentially could make a resource that explains it and then addresses that issue of the obstacle of time constraints. Number 4, a court patron would like to change their name. They ask you what they need to do. They're particularly concerned about a couple of arrests that they had and ask you if they have to tell the court about them. They also want information about how to change their child's last name on the birth certificate because it is not the correct father's last name. What can you do? Of course, you can give them forms and the related instructions. There are statewide standardized forms for name change, so there's a resource directly to give them. The policy also allows you to explain the nature of the information required to fill out those forms. So that person's question about if they have to list their arrests or not, if you look at the form suite, on the very first page, the Getting Started page, it does explain that you have to list criminal records, and there's more information about that throughout the packet. So you can point out that portion of the form. You can even tell them what that portion of the form says. However, you do not want to make any sort of assessment about their criminal record being disqualifying or not. So you don't need to ask questions about what their record is or make a determination about whether that would let them or disqualify them from changing their name. All you're doing is letting them know what's required based on the information that's in that form's information suite. Something else to think about for this question, the mention of a child's last name. This is something that you may want to get a little bit more information about for the sake of making a proper referral. So this might be something that would need to go through the court through the minor name change process, or this could be something that would go to a different government department, like the Department of Public Health, for a birth certificate correction. Either way, you're not going to make that determination about which path they need to take, but you may want to be able to give them all of their choices. And referrals to other governmental agencies like the Department of Health is allowed under the Safe Harbor policy. The next scenario. A self-represented litigant lost their civil case 2 months ago and now wants to file a notice of appeal, but told you they had to borrow money to pay court fees. They want to know where to find more information about appeals. What can you tell them? One resource that we hope all of you know about, but if not, you'll learn about it today. The Illinois Courts website has a section for self-represented litigants and civil appeals. This has a wealth of knowledge about frequently asked questions, a guide to civil appeals specifically made with SRLs in mind, a one-page overview of all the timelines and requirements for appeals, as well as videos that walk people through the appellate process. But as you know, appeals are very confusing, and so you can always encourage self-represented litigants to try and get a lawyer or get advice from a lawyer. In fact, there's a new resource online where they can ask questions through pilly legal answers and get a response from a pro bono attorney. Referrals to those sorts of resources are allowed under the policy as well. Because the person mentioned having to borrow money to pay court fees, you can also inform them about fee waivers. You can direct them to the standardized forms, and anytime someone mentions something about filing fees or money or borrowing or not having enough, you can always tell them about the fee waiver option. You're not making any sort of assessment about if they qualify or if they get it, but just informing them that it is a form of relief that is available to them and they can choose whether or not to file for it. One thing you want to be careful about is making any sort of assessment about timeliness of an appeal. You might know that notices of appeal usually need to be filed within 30 days of the case ending, and this person mentioned their case ended 2 months ago. This isn't for any of us as court staff to tell someone that their appeal would be untimely or that it's not going to go anywhere. That would violate the policy by making a recommendation about whether a case should be brought or giving an opinion about what would happen if it's brought. It's merely up to the court or a judge to decide those sorts of things. So make sure you're not crossing the line into any sort of assessment or suggesting that someone not file something because you think it might be untimely. Our last scenario. Someone at the courthouse finds you and says they want to evict their tenant. They've never had to do this before and they have no idea where to begin. They have a lot of examples about how terrible their tenants are, from having loud parties to trashing the place to being late on rent to not paying rent the last 3 months at all. They heard the eviction moratorium is ending and they want to get their tenants out. What can you tell them? You can always remind court patrons that you can only provide them legal information and not legal advice, so you don't need to have the details of their case. This not only saves time, but also saves you the trouble of potentially crossing the line into advice if you know too much information about their case. But as we've talked about with every scenario, you can always explain the court process to people. So any landlord who's coming in trying to find out how to evict a tenant, you can explain that court process to them. Additionally, you can give them forms. We have a newly published suite of eviction complaint forms with instructions that they can look through and use. And during this pandemic time, there's a couple of other things that you want to make sure that if people are talking about eviction, that you know about and could make referrals to. One is referring them to any government agencies for rental or mortgage relief funding. And the other is to just know about the moratorium. We have information on our state site for the forms that explains both the governor's moratorium and the Centers for Disease Control moratorium. So you can refer them to that form site that has that information there to know whether or not it is appropriate for them to be doing their case, and that's for them to decide. As you can see from all of our scenarios today, there are some things that you can always do. Describing the court process is one of them, and we talked about that on every slide. However, there are some that we didn't mention that I just want to make sure that are always in the back of your mind. So referring to internet-based resources like Illinois Legal Aid Online or the court's website, whether it's the circuit clerk's office, the local court, or the Illinois court's website, any of those internet-based resources can be referred to under Section D10 of the policy. And you can always encourage people to get a lawyer under Section D11. However, certain locations have more legal aid resources than others. So encouraging someone to get a lawyer or telling them the only way they can get any help at all is to talk to a lawyer isn't going to be particularly helpful in locations that don't have a lot of legal aid resources or help desks or easy access to lawyers. And you can always make referrals to other organizations as appropriate under Section D10. So make sure that you take a close look at that section. There are many different types of referrals, from those alternative dispute resolution referrals that we talked about earlier, to government agencies, to many types of legal services. So make sure to take a look through that section. And just keep reframing all of the questions and answers that you are giving. So you want to avoid saying that you can't help someone at all. There are very few circumstances where that's the case. At the very least, you can give them a referral, give them basic information about the court process, give them something, and that will certainly improve their experience with the court system as a whole and increase their public trust in the institution. If you have any questions or want more training for your staff, your local courthouse, please reach out to the Access to Justice Division at accesstojustice@illinoiscourts.gov. We will travel to or do virtual training for your entire staff, for multiple staffs put together. Depending on what's safe at the time, we will make sure that you get the information that you need. We are happy to answer questions one-on-one as well, but are happy to do broader trainings similar to this, but hopefully more interactive if it's not through a recorded webinar. So please reach out, not only for training, but also for any resources. We have courthouse signs that can be useful, not only about the safe harbor policy that I showed you today, but other access to justice topics like language access. And the offer for training isn't just for this topic, it's for any access to justice topic that you're interested in. So reach out, we can discuss what options are available and make sure that we're providing you with the information and resources that you need. In addition, we're always looking for suggestions, and we always want to hear from those of you on the front lines working with self-represented litigants about what they need and what they're asking about, which can help shape what resources we create. So please reach out with suggestions, with questions that you're hearing really frequently that we can potentially make handouts for that you could easily give to court patrons. That saves time for you as well. Just keep those lines of communication open. We want to hear from you, and we want to help you in any way that we can. Thank you for listening today and learning more about legal information versus legal advice. This concludes our presentation.